Good morning, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal litigation to enforce the USCIS Form I-864. One question I get all the time is from sponsors, which is, can I withdraw the Affidavit of Support? Once, so maybe, as is often the answer in law, the answer is it depends. And what it depends on mostly is whether status has been granted to the immigrant. So after somebody achieves residency on the basis of an application that included an affidavit of support, that affidavit of support is then locked into place and cannot be withdrawn until, well, it can't be withdrawn, period. And it's not terminated until the 5 terminating events defined by federal law. So when can the affidavit of support be withdrawn? Well, it can be withdrawn if the person has not yet obtained residency status or had their immigrant visa issued. In short, there are basically 2 paths towards residency on the base of a family-sponsored petition. One is called adjustment of status, which happens within the United States. Sometimes it's called a green card application. The other is consular processing through a U.S. consulate abroad. In either case, the affidavit of support can be withdrawn only if that process hasn't yet reached a successful conclusion. So in the case of adjustment of status, if the person hasn't yet had their I-485 application approved, that's the adjustment of status application. And in the case of consular processing, the affidavit can be withdrawn only if the person hasn't yet had their immigrant visa application approved. After either one of those is true, adjustment of status granted or immigrant visa application approved, the affidavit of support is effectively locked into place. That's how the policy is supposed to work, because under the statute passed by Congress in 1996, the affidavit of support is intended as an insurance policy for the recent immigrant. The idea is that once that person comes to the United States on the strength of family sponsorship, the person who served as the petitioner in that case is considered to be a financial guarantor for that immigrant until the affidavit of support is terminated as provided for under federal law. So that whole legal regime wouldn't make any sense if the sponsor was allowed to put up their hand and say, yes, I agree to serve as a financial sponsor, and then they could just back out of that whenever they wanted to. But federal regulations don't allow that. 8 C.F.R. 213A.2 subsection F specifically deals with this. It's also right there in the statute at 8 C.F.R. 1183A1. And the regulations say very clearly that once somebody has adjustment of status granted, once an immigrant visa application has been granted, the affidavit of support cannot any longer be withdrawn. There is no process for doing that. Federal law doesn't allow it. And that is true regardless of whether you are a primary sponsor or a joint sponsor. The same rules apply. And there is no process whereby you can bring in another person and swap out sponsorship. Once you've signed the affidavit and the person gains status, that affidavit is locked in and you can't trade responsibilities to somebody else. Why? Because that's just not the way the federal law is written, period. I know that's not what everyone wants to hear, but that is the bottom line from a federal law standpoint. Once somebody has achieved status or has an immigrant visa granted on the basis of an application that included your affidavit of support, it is locked into place and cannot be withdrawn. If you have questions about the affidavit, feel free to drop them into the comments and I'm happy to answer them. If you would like an individualized case assessment and your rights under the affidavit of support, reach out to me on the website. We do free Zoom consultations all across the United States. Hope that's helpful. Bye-bye.